Good morning, Your Honor. May it please the Court, my name is Hayne Barnwell for Kenneth Hamilton. In this case, the Commonwealth failed to provide probable cause or sufficient evidence to support the charges and convictions against Mr. Hamilton of intimidation of a witness and threat to commit a crime. Starting with intimidation of a witness, the intimidation of a witness statute, even after its amendment in 2006, continues to require that a defendant specifically intend, quote, impede, obstruct, delay, harm, punish, or otherwise interfere thereby with a criminal proceeding of any type. When Mr. Hamilton left the voicemail message for his former probation officer, all criminal proceedings against him had long since closed.
So the question is whether the statute encompasses retaliation. Isn't that the question?
Yes, Your Honor. The Commonwealth argues that the addition of the word punish encompasses conduct that retaliates against a witness for prior testimony in a past criminal proceeding.
What else would punish mean?
Well, punish actually has two definitions. One is retaliate, as the Commonwealth maintains. The other is harm or hurt, or I believe to deal with roughly or harshly. And this case actually can be resolved quite simply because in the statute, or the section that we're really fighting about, punish or otherwise interfere thereby with a criminal proceeding.
How can you punish a criminal proceeding? So you certainly can't be saying that's how we should interpret the statute.
Well, you can't. When I first read that, I thought the same thing. How do you retaliate against a criminal proceeding? And then I looked up punish in the dictionary, and the only way that sentence makes sense is if you say to harm or hurt the criminal proceeding. And in the context of the statute, that's clear because the word otherwise, punish or otherwise interfere with, means these terms should be used interchangeably. And so that, to me, is the more reasonable and natural meaning in that particular section.
Would a complaint for threats have been appropriate here?
I'm sorry, complaint with threat. They did charge threat to commit a crime, and I'm also arguing that there's insufficient evidence on that charge as well.
But that's just because of the victim. That's not because of, the naming of the victim, right?
Well, yes, because the Commonwealth claimed that the probation officer was the target/victim when really it was the daughter who was.
But you're not disagreeing that there were threats, that there would be enough for a complaint of threats. I think your problem with that complaint is about who was named as the victim.
Well, the other problem I have as well, Your Honor, is that there wasn't sufficient evidence at trial to show that Mr. Hamilton intended that message to reach the daughter, or that he would have known that would have been, and the Commonwealth concedes that.
So if I say to you, unless you do this, I'm going to kill your child, that's not a punishable threat vis-a-vis you, unless I intend you to convey that to your baby, your child. Is that right?
Right. The Commonwealth does have to show that the defendant intended to convey that message to the daughter or the child.
Well, the problem is with the statute as it applies here, because the statute says do harm to the person or property, and the judge instructed that the defendant must communicate to the victim an intent to injure or harm her person or property. And how is the child of the probation officer the probation officer's person or property?
And that's exactly the point I make in the reply brief. And there's a case I cite, Brustein, because I didn't see any law with this particular statute on that point, but there is a case, Brustein versus New York, I believe. Sorry, Brustein versus Amsterdam, out of New York, that says for a claim where the wife is trying to recover, I can't remember, loss of injury, the wife is not the husband's person or property. The same thing applies here. The daughter is not the mother's person or property.
We hope so.
We hope so.
But isn't that an enormous, dangerous loophole? Under the law, I can't threaten to kill you, but if you have an infant, I can threaten to kill your infant, and according to you, I can't be punished for that.
Well, it's a disturbing message, and the mother has every right to be upset, but it's not a crime under this statute. It might be a crime under another statute. The legislature is certainly free to amend this statute.
Well, tell me, what does the statute say? Threaten to commit a crime against the person or property of another. All right? So your client is, certainly we could read the evidence to suggest your client has threatened to commit a crime against the person or property of another. All right? So what else has got to be proved?
Well, the threat is against the target, not the messenger. So the threat here, I mean, the threat if carried out, and I believe that's Commonwealth versus Shawley, the threat if carried out has to constitute a crime. The crime is only against the daughter, not the mother.
But is the problem that is it judicial gloss on that language? Because if you just take the language by itself, it would seem to encompass what it is the Commonwealth is alleging here. Your client threatened, or allegedly threatened, to harm the person of another, the person being the child, but the threat was conveyed to the mother, and there's nothing in the statute that requires the knowledge to be then transferred down to the child.
Well, I'm reading the statute. The person has threatened to commit a crime against the person or property of another. The way I interpret that is it has to be against the target, so the target here would be, at least this Commonwealth claim, is the mother, not the daughter. So,
But why is that so? This is the way you're interpreting. Why is that so? It certainly has to be a serious threat. In other words, it has to be presumably by someone who has the ability to carry through and is sufficient to cause apprehension. We've got all of those factors here.
but, well, even if the child is encompassed in the statute, I don't believe it is, but even if that's true, we still have Commonwealth versus Maiden and that line of cases that says that the defendant must still intend that that message reach the target, the daughter, in this case, the daughter. And the Commonwealth concedes that.
Is that always the case? I mean, that's a third-party threat. I mean, here, your client presumably is not threatening the daughter, is threatening the mother. To commit a crime.
With what? That's the main question. With what? Really, the threat in that case would be emotional distress, and emotional distress is not an injury that constitutes a crime.
But the problem here is with the judge's instructions. Regardless of what we say that the law says, the judge said first that the defendant communicated to the alleged victim. That's Ms. Sion here. That's the probation officer. Communicated to her, Ms. Sion, an intent to injure her person or property now or in the future. And that's, he just didn't. He didn't communicate to Ms. Sion an intent to injure her person or property. He communicated to Ms. Sion an intent to injure her child.
Yes.
And I think the judge's instructions are what makes this case fail, it seems to me, as far as the Commonwealth is concerned, on the threats.
Yes, I agree, and I do make that claim that the jury instructions fail in that sense. So at least there's a variance between the complaint and the evidence, and so at least he's entitled to reversal of his convictions.
No, didn't the complaint name Ms. Sion as the victim?
No, the complaint names no one as the victim, does it?
No,
The
complaint just says you threatened to commit a crime.
The original complaint, I did file the original complaint with you. The copies were all redacted, but the probation officer is listed as the victim, as the complainant.
So the complaint and the instructions comported with each other.
Yes.
And well, to me anyway, that creates a real problem.
Exactly. I agree with you.
Is the requirement that the threat be conveyed, I guess this is a third-party threat, that's not part of the statute, obviously. That's how the courts over years have interpreted it, right?
Yes.
Would you agree that your interpretation is contrary to common sense? If you say to a parent, I'm gonna have a predator do harm to your 7-year-old daughter, doesn't common sense say that that's a threat to the parent?
No, Your Honor. Again, the mother is understandably upset. So the mother, in this sense, is the recipient and possible messenger. So the messenger is upset, but that doesn't mean there's a threat to commit a crime against the messenger.
But does it make sense for the parent, in this case, to communicate the threat to a 7-year-old child who's going to become visibly upset or understandably upset as a result of the communication and isn't going to be in a position to do anything about it? It's the parent who has the obligation to do something to protect the child. And here the threat, I mean, it's not just emotional harm. It's emotional harm that's resulting from a threat of physical harm to a child, to the protectorate of this parent.
There was no evidence that she communicated that threat to the daughter or that Mr. Hamilton had reason to know that that would occur, and the Commonwealth does concede that he only intended that message to reach the probation officer. So to me, end of case.
But that's the point, though. The threat really is to the parent. The resulting harm is emotional distress to the parent. but the resulting harm is arising out of physical harm to a 7-year-old child. There's an integrated component here that you don't seem to be talking about.
Well, there is that. I suppose if the legislature wants to integrate that into the statute, it's free to do so, but it's not free. This court is not free to do so.
So if you prevail, and we agree with you, the rule of this case is that people can threaten the children of anyone they wish, and that will not be treated as a threat.
The Commonwealth
unless the child receives the threat.
If the Commonwealth can find another statute to charge the person under, but it's not a crime under this statute.
Well, what if the child is an infant? And is the parent going to communicate the threat to a 6-month-old in order to perfect the crime? I mean,
that brings up another element, I believe. Would the victim, in this case a 6-month-old baby, reasonably understand this to be a threat? So I think that's how it would work.
But isn't the problem here, as you're interpreting it, at least as I look at it, if I look at the words of the statute, it seems to me the words of the statute cover what it is that we're concerned about, that it be a crime for somebody to threaten a parent with injury to her child. It seems to me the words of the statute can be read to encompass those acts. And so that
I'm sorry.
Well, so it seems to me that the issue here is what have the courts done in interpreting the words of the statute over the centuries, or years anyway.
That is a problem, and I have not found, and I don't believe the Commonwealth has found any cases on point about that specific language. What does against the person mean? Does against the person mean a child or a near family member? How far does that go? A cousin, a brother? To me, it should be read narrowly. Criminal statutes, after all, must be strictly construed against the state. And if there's any ambiguity, the ambiguity is resolved in favor of the defendant. So, if I can return, I'm sorry. If there are any, unless there are more questions on the threat charge, I'd like to return, if it's all right, to the intimidation of a witness. As argued before, the Commonwealth argues that punish means solely retaliation. My position is that at best, they have an ambiguity. There's an ambiguity in the statute, and it should be resolved in favor of the defendant.
The Commonwealth, I think it's the Commonwealth, talks about, the change in the statute, that it used to actually have two parts, one of which was explicitly about retaliation, as I understand it, and then they got conflated somehow. Is there, and I understand the statutory language changed, but I wonder, I don't think the Commonwealth talked about this, whether there's is there any legislative history as to what this word punish was intended to do here?
I'm sorry, I have not found any legislative history about punish. The legislature, unfortunately, does not define the word. The legislature does define harass, but not punish or even criminal proceeding, which is problematic. But the past statute, I think the very last statute actually did have, if a defendant causes physical injury on account of or in a retaliation for the testimony, then that can be prosecuted, which I actually find interesting because they were clearly thinking about the First Amendment, because physical injury kind of ties it to a real harm for past testimony, whereas you get into overbreadth problems if, say, 50 years out, you harass a former witness for past testimony, criminal proceeding, you get into first overbreadth.
But the crime occurs when you threaten a probation officer in connection with a criminal proceeding. Right? So the threat may be years later, but that's when the crime is committed.
I believe Your Honor is referring to just the title of the.
No, whoever.
It says in connection with a criminal proceeding. In the title.
Whoever directly, willfully threatens a probation officer.
Right, that's two. And then the third is with the intent to impede, obstruct, delay, harm, punish, or otherwise interfere thereby with a criminal proceeding of any type. So
your point is, if the criminal proceeding is over, how can you have an intent to obstruct, et cetera, because there's nothing left to obstruct.
Exactly. One cannot delay a criminal proceeding that's closed. So that would be my argument. See, my time is up.
Thank you,
Thank you.
Counselor.
Good morning, Your Honors. May it please the Court, my name is Ann Peruti. I'm an Assistant District Attorney from Middlesex. I was also the trial attorney. With me today is Assistant District Attorney Kevin Curtin.
So help us with this statute.
I will, Your Honor, if I can. First of all, contrary to the defendant's claim, the defendant's threat to have his probation officer's 7-year-old daughter sexually assaulted is clearly sufficient to establish a violation of the witness intimidation statute, Chapter 268, Section 13B. In this case, it was directly retaliatory, made towards the...
Do we have to have an ongoing criminal case?
We don't, Your Honor. As defense counsel in the court has noted, the prior version of the statute, which was the most recent was the 1996 version of the statute, had two discrete forms of misconduct, as recognized correctly, I would say, by the appeals court in Kathy C. Those two discrete forms of misconduct, were interference as evidence with certain types of behavior, and then retaliation. Interference could be constituted by threats themselves. In the old statute, retaliation could only be brought about by means of physical injury to a person or property. When the new, I'm sorry, Your Honor, after Kathy C. recognized that gap, which this case falls squarely into, that is, where threats can constitute retaliation. After that, the appeals court made that recognition in its decision. The legislature amended the statute to the form where it was in 2006 and at the time of this trial in 2008.
What do you do, though, about the fact that all these words, you have impede, obstruct, delay, harm, then punish, or otherwise interfere thereby with a criminal investigation, et cetera. Once you add that or otherwise interfere, doesn't it mean all those words are of a piece?
I don't think it does, Your Honor, because if you, as Justice Cordy recognized, it wouldn't make any sense to punish a criminal proceeding.
Well, how about the word just doesn't make sense? I mean...
But I think it does. If you look at the plain meaning of punish, as counsel recognized, to inflict a penalty on in retribution, the way that every person of reasonable intelligence understands punish is specifically, chiefly in that regard, to punish somebody for past behavior.
In the structure of this sentence, it doesn't make sense.
I think, Your Honor, if I would agree that it doesn't make sense to punish a criminal proceeding. However, I think that you can read each of those 5 specific verbs as affecting either a person or a procedure. And then I think it's reasonable to read that last 6th item, or otherwise interfere thereby, as more of a catch-all phrase, where you're talking about the legislator identifying specifically identifiable means of affecting a witness or a juror, or in this case a probation officer, in connection with that person's role during a criminal proceeding.
But how do we know whether or not the legislature in 2006 meant to eliminate the penalty for doing something that may not relate to an ongoing proceeding, but wanted to include the concept of punishment in order, but limit it to ongoing proceedings? That is, to punish a grand jury witness for testifying in the grand jury, but the proceeding must still be ongoing. Why is that not a reasonable understanding as to what the legislature did here?
Well, I think, Your Honor, if you look at what the broader purpose of the statute was and continues to be, as you can see in the emergency preamble to the statute, the amendments were part of a larger scope of amendments aimed at reducing gang violence. It wouldn't make sense keeping that overall and overarching goal, as the appeals court noted in Kathy C. It's not just to protect individuals as they're testifying at various proceedings, during the realm of a criminal trial, for example, from beginning to end. It was also, on a broader level, to protect against protect the administration of justice. And in this case, it would not have made sense for the legislature to take a statute which already protects people from retaliatory conduct to a certain extent when they're broadening the scope of protection for witnesses on a general level to have narrowed that protection in this specific statute.
And let's assume you're right as to the legislative intent, but how does that affect the requirement under the rule of lenity of giving fair warning? Is someone supposed to go back to legislative history to discern what the language means when the language does not plainly say that it includes conduct with regard to a proceeding which is now ended?
Absolutely not, Your Honor, because in this case, specifically, we're dealing with the word punish here. In our case, the meaning is the ordinary meaning that we use every day is plain, and it applies in the way that we're construing this statute
But
here.
my point is you can understand the word punish and still limit it to an ongoing proceeding because the person may have testified many times, may have testified in an earlier proceeding, at a motion to suppress, at a grand jury. So you can still punish even during an ongoing proceeding.
You can, but that doesn't, because you can punish during the pendency of a proceeding doesn't mean that you necessarily can't punish after that proceeding is done. And other language in the statute would put reasonable people on notice that retaliatory conduct is not allowed and is expressly prohibited by the statute. If you look at,
what language specifically is that?
for example, if you're looking at the definition of the types of protected people, it says a person who is or was aware of information, etc. A person who is or was furthering a criminal investigation, a person who is or was attending. And when you look at the last clause in the statute, which defines where or the jurisdiction that courts have over violations of the statute, it talks about it's subsection 4. A prosecution may be brought in the county where the criminal proceeding is being conducted or took place. So looking at that other language which had been added in as part of that overall amendment, it also points to and puts a person on notice that it's not just what's about to happen, it's about what has already taken place.
But doesn't that merely say that the prosecution for intimidation may occur after the underlying case has ended, and therefore you need the past tense to address that possibility?
I think that's one of the ways you can read the past tense, most definitely, but I think it also makes sense to pay attention to that language when you're thinking about whether or not punish means what we all understand it to mean, that is, to retaliate against someone or inflict a penalty on them in retribution for something they did, or if we're adopting in a logical sense of the word, which may be a secondary definition, to deal with harshly or roughly. Yes, that's one way somebody might interpret punish, but it's not the first way that any of us, I would argue, would interpret that word, especially when you're talking about the context of the word and the language that surrounds it. There's no requirement for an ongoing proceeding. That's not something that was affected by the legislature's amendment to the statute.
What about the threat statute? Can emotional injury constitute the harm?
Well, with the threat statute, I think that that's a separate question than what the defendant was actually arguing. In this case, when several of the justices asked about what you actually need to prove for a violation of the threat statute, and if you look at the language of the statute itself, it references harm to the person or property of another. It doesn't say of the person being who's receiving the threat.
No, but the judge instructed the jury in this case
The
that
judge-
it was the person or property of Ms. Soane, whatever her name, the probation officer.
Correct, he did. However, Your Honor, first of all, there was no objection to that instruction. Second of all, the evidence that came in was not, as defendant is trying to paint it, as that of a third-party threat. As some of the justices have recognized, this is not a case where the Commonwealth needed to prove that that Catherine Sione was actually the conduit for the threat to this
But I don't even get
young
there
woman.
because I'm stuck on the judge's instruction. How, if the jury is wrongly instructed as to who the victim of the threat is by the judge, and he says the person or property, he doesn't say emotional harm.
But the crime, because the crime, as some of the justices recognized, the crime threatened was not emotional harm to Ms. Sioni. The crime threatened was the
Harm to her
rape
daughter, I understand
of her
that.
daughter.
But that isn't harm to the person or property of the probation officer, unless you're going to say the daughter is the property of.
I think that that's something that, well, the jury obviously didn't have any problems with that. I don't think there's a substantial risk for miscarriage of justice where the evidence fits into what the elements of the crime actually are, regardless of, which I would suggest are different as elucidated in the case law than what are perhaps, I think, slightly different as they're written in the jury instructions, which obviously
So how should the jury of instruction read?
Well, I think in this case, it would have been prudent for either of the parties to request a different instruction than the model instruction in order to conform to the actual evidence that came through. As the courts have recognized over and over again, the elements of a threat is an expression of intention to inflict a crime on another and an ability to do so in circumstances that would justify apprehension on the part of the recipient. In this case, there was a threat proven where the defendant, Kenneth Hamilton, expressed an intention to inflict a crime on another. That is, have Catherine Sioni's 7-year-old daughter sexually molested by a predator that he met in jail. And there was an ability to do so in circumstances that would justify apprehension on the part of the recipient.
Doesn't it seem to you that there's a gap in the statute?
I think that this is a factual scenario that might fall into that type of gap if we're, for example, limited to the jury instructions that have been proffered for use in the district
But the
court.
statute could say threatens to do harm to the person, property of another, or to cause emotional injury.
It most definitely could. I don't think we need, in order to prevail on this count, I don't think that the Commonwealth would have needed that added phrase there. I would agree with the court that it might make things clearer in the future for that to be added on, but I don't think it's necessary in order to prove Kenneth Hamilton guilty of threatening Ms.
Your
Sioni.
view is that a threat that may cause emotional injury is sufficient? That a threat whose sole harm is emotional injury is enough?
I'm sorry, I didn't understand the question.
Is it your position that a threat where the sole harm is of emotional injury and not physical injury is enough?
No, and that's not what my position is here today. My position here today is that a threat was made to inflict harm on another person, that harm constituting a crime, and that the defendant had the ability to do so.
That person being the probation officer or the child?
The child.
Okay, and what do we do with all the case law that says that it must be intended to be communicated to the ultimate victim? What do we do with all that?
Well, that's a separate situation. I think that case law is fine. If this were a case, for example, where he had threatened to harm her husband, somebody who the recipient, in this case Ms. Sioni, he should have expected to communicate that threat to, then that's a different situation. This is not a third-party threat. Catherine Sioni is the intended target of this threat. Kenneth Hamilton, the defendant, made that threat in order to hurt her. She was the intended recipient and victim of the threat, and she was correctly named as such in at least one of the complaints that was in existence in this situation. The fact that there was another person involved, as the court has recognized, there's no expectation on Mr. Hamilton's behalf or anyone's behalf that she would then communicate that to her 7-year-old daughter. The daughter did nothing to even gain the defendant's attention as far as retribution or retaliation is
I understand
concerned.
that, but the problem is that we have substantial case law that says that the intent required is to intend to threaten the person you're speaking with, or you intend that threat be communicated to the person who you're threatening. And it doesn't fit here because she's 7. So what do we do with that? Do we simply say we're going to now adjust our case law to incorporate it? And is that fair to this defendant for us to change the law after the fact?
I would agree with Your Honor that this set of facts doesn't fit into that mold of the third-party threat. But I don't think that means we need to change that whole string of cases that talk about what the Commonwealth needs to prove in situations of third-party threats. What I'm saying is this isn't a third-party threat precisely because of the nature of the threat and the context of the relationship in which it was made. This is, if it were a third-party threat, then the Commonwealth would have had to prove those extra elements, but it's not. The Commonwealth never had that or expressed that as its theory of the case, and the Commonwealth maintains
But I still
that
don't see how it makes it her personal property.
I don't know that, or what I'm saying, Your Honor, is that the Commonwealth, although the jury instruction
Boy,
does say that.
substitute, it was a threat to Mr. Sion, an intent to injure his wife. Would you tell me that it was an intent to injure the personal property of the husband by making a threat about the wife?
Absolutely not. I think that's an
Okay, well,
entirely
same
different
thing.
situation.
No, same.
But when you're talking about the intelligent capacities of a minor child and a man who's married to the recipient of that threat, I think it is distinguishable. And in that situation, I would agree with you 100%, that would be a third-party threat. When we're talking about threatening to sexually molest somebody's child, I can't think of any other threat that would be...
That would create such emotional injury.
Yes, which is important for purposes of the intimidation statute. But when you're talking about a minor child or an infant, in this case the girl was 7 years old, it was unrealistic and never contemplated that that threat to have her raped or sexually assaulted would have been passed on to her. Catherine Sioni is the target, she was the recipient, and she was the one who was designated and should have been designated as the victim of the threat. And I don't think that if looking at the expression of the elements as it is consistently throughout the case law requires this to be looked at as a third-party threat scenario.
Thank you, counsel.
Thank you.
We'll take a brief recess.